Good evening and welcome to Stanford Gould number 3 session about collaborations and contracts. First of all, apologies that we are an hour earlier than I said I would be last week. As ever, timetables have just shifted, and so I needed to come on the stream a little bit earlier. So apologies if you think I'm going to be there at 7 and you're now watching this on the replay thinking, I missed it. I'm so sorry. So tonight is number 3 in our series about collaborations and contracts. As always, if you are watching live, please press the little thumbs up blue button at the bottom to say that you're on stream and watching. And if you'd like to make any comments as we go along, please feel free to put them into the comments box. If you're watching on the replay, again, drop comments into the box or questions and I'll try and come back to you and answer them as soon as I can. So today we're talking about ownership within an associate's contract, and really that's about who owns what in terms of what's produced under the contract. So primarily this might apply in a situation where you've got an associate working for you, and between the two of you you may produce an end product for a client, which is what most scenarios are going to be. And that product might be photography, it might be something written, it might be something artistic, it might be something technical. It can be anything, but there is a right that exists over that piece of property. Who does that belong to? So this associate is going to be working for you. Does it automatically belong to you? It was created by the associate. Does it automatically belong to them? Is it shared? What happens if it becomes the next big thing? Those are my inverted commas. In the next big thing, and makes a shed load of money. Who gets that money? These are all questions that can be tackled in your contract. This is particularly true if you've got someone who is essentially doing what you do in the normal course of your work, but as another additional person doing the same thing. So let's put some examples because it's easier with something real. If you are someone who delivers training, and because you are maxed out, you get another person to come in and deliver a set of training materials or a course that you have created, and all they need to do is turn up and deliver the course. Now, in that situation, you'd think, well, that's pretty obvious. The copyright or the intellectual property in those materials is clearly mine. I've given it to the associate to go and use it. I retain the copyright. But what if over time that associate starts to adapt and change and add and enhance what you have? Does that still all belong to you? Or do they have some right to that? So these are things that you need to think about at the start of a relationship. What are you asking them to do? What physical things are being produced as a result of that instruction, and who's going to own them? And those physical things may be quite esoteric. They can be on the internet, they can be soft as opposed to real physical tangible things. But think about what's going to get produced, who's going to do the work for that, who's going to get the benefit of it, whether you're both going to be able to use it at the end, and make sure that the contract tries to cover those scenarios as best you can. Now, maybe that if, I don't know, if you were working for Mr. Dyson, or Mr. Dyson, God help you, was working for you, or something like that, and they produced something absolutely stunning and you thought, wow, this is a proper piece of kit, we're going to make shed loads of money from this. You wouldn't probably rely on the provisions in your associate contract if you thought that something had been created that was really a goer and you needed to think about how to exploit it properly. In that situation, you'd create a new contract. But for most people, in most situations, just dealing with the question of whose input and whose effort and whose benefit these things are going to have, it's worth dealing with. The second thing that I want to speak about this evening, which sort of stems on from that, is the question of confidentiality, which is also something that needs to be dealt with in a third-party contract. You may be presenting your associate with material that is quite sensitive. You might be giving them price lists, you might be giving them client lists, you might be giving them client contact information. You may be giving them a trade secret of sorts, so perhaps a particular way in which you produce what you produce, or a particular methodology that you use that is entirely bespoke to you, that you've created, and you want them to keep that confidential. This is particularly true if you've got an associate who works for other people. So they may not necessarily work in a competitive sector. We talked about this before, see video 2. But if they work for someone, I think, oh, I've got something that does that job, perhaps we can just borrow it, put it into this arrangement. You want to make sure that if you have got stuff that you want to keep confidential and you want to make sure is not used by somebody else who hasn't slogged to get it right, make sure that's treated as confidential. Some material will automatically be treated as confidential under law, and you will have certain exceptions that you're allowed to disclose confidential material, even if you've agreed that all material will be confidential. And that means things like pay information and tax information, or something that a police investigation was interested in looking at, for example, that wouldn't necessarily be covered by confidentiality. But confidentiality is the other thing. We're a little bit like the ownership of materials. It's the ownership of information and where it can be disclosed and to whom it can be disclosed. There is a third element, which is the delightful topic of data protection. Goodness me, I am not even going to attempt that one tonight. You may be aware that there's a massive shift in the law coming up next year, and people are getting very geared up for the new GDPR regulations. They will extend to everyone, and they will make data protection a whole lot more robust, potentially more complex, and certainly something that you'll need to deal with in a contract. But we'll save that joy for another day. If you've enjoyed this video, please do comment, please like, please share. I think we've got one, possibly 2 more in this series coming with other provisions about associates contracts. We will not be here next week because I have a previous engagement doing this, but face to face with real people in a real room, doing real teaching. Goodness me, scary stuff. So I won't be here next Monday. The following Monday, hopefully we'll be back to our 7 o'clock slot as usual. Thank you for listening in. Hope you found that useful and informative. And as I say, do pop your comments or any feedback that you have about any of these videos or any of the material on the website that you've had a look at. If you want me to comment or help you, be more than happy to. Drop me a line. It's good to speak to you. Thanks very much. Bye-bye.